Hello. Are you not hot?
No, it feels really good in the sweater.
Oh, okay. All right. So what is happening on this case?
Yes, Your Honor, the state has made an offer of mental health PTD on one of the misdemeanor cases. Once we are going to ask for a reset so we can apply into that course.
Okay.
And once he gets accepted, then I believe this felony case is going to be TIC'd along with all the other thefts.
All right, Ms. Ferguson. So you're doing PTD in misdemeanor court?
Yeah, yes, Your Honor.
All right. Can we reset this for 30 days for an update on the misdemeanor PTD?
And Judge, just to clarify, it's gonna be the mental health court, PTD.
Yes.
Mental health court. Okay. What date, Ms. Ferguson? Yes, it's for mental health.
This is your first quiet warning bell. Mental health court is not a free pass. It is a structured, closely watched second chance. Miss Ferguson is stepping into a court lane where every appointment, every signature, and every report suddenly matters a lot. Viewers, here is the question. If the court offers you treatment instead of punishment, are you more likely to change? Or more likely to slip?
Oh, yeah. Thomas Henson. Oh, just 1 second. Are you all ready to proceed on the motion?
Yes, Your Honor.
Yes, sir.
All right. Is this going to be contested or no?
No, Your Honor.
All right. I don't have an. I do. All right. The court is calling 2022 CR 5859 State of Texas versus Thomas Nathaniel Henson. Can I have parties announced for the record for the state,
Zach Dunn for the state.
for the defense?
Catherine Valenzuela.
Are you Thomas Henson?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes.
Are you the same Thomas Nathaniel Henson who was placed on deferred adjudication in 2022 CR 5859 for the offense of aggravated assault with a deadly weapon on September 15, 2022 for a period of 4 years?
Yes, ma'am.
State?
Your Honor, on or about the 11th day of August 2023 in Bear County, Texas, the defendant, Thomas Nathaniel Henson, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
State,
And Your Honor, there's an agreement.
the other allegations?
There are none, Your Honor.
Are you waiving?
Yes, Your Honor.
All right, any objections to the waivers?
No objection to the waivers, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yeah.
Court will find violation of condition number 1 true. Is there an agreement?
This is a legal cliff edge moment. By pleading true, Henson just handed the judge the full power to send him away for up to 20 years. The courtroom might sound calm, but this is a chessboard square where one wrong step can end the game. Ask yourself this. Would you gamble your freedom on a promise to do better later?
The wait time is 6 to 13 weeks. Do we have any other alternatives?
State ISM cognitive track, Your Honor, that wait time.
All right, but will that address the issue? Because DDRF, I'm assuming there's a mental health issue.
And Your Honor, that had been the first recommendation. Then he did the tap about, and that's why we got to NDRF. But the first recommendation had been ISF cognitive.
All right,
Sorry.
no problem.
So yes, the original recommendation was for the state ISM cognitive track, but we did an updated tap while he's been in Bear County, and the recommendation changed for DDRF due to the mental testing.
All right, so the new number 1, who is the complainant? I mean, what is the relationship?
She been my girlfriend.
Girlfriend. All right, and are we doing no contact with the girlfriend?
I believe there had been, she did sign an affidavit of non-constitution. We did enter plea to proceed with the treatment that he believes he does need, Your Honor.
All right, so I'm going to order no contact with that person. And then once his mental health is stable, we'll
This is where the case turns personal. No contact orders are courtroom firewalls. They are built to stop emotional chaos from turning into legal disaster. When the judge says that relationship is over, it is not advice. It is a legal boundary with prison bars attached.
report. I can't hear you.
I wasn't living with her. She was staying with me, so.
All right, so do you have your own place?
Yeah.
So who were you living with?
Yes, I was staying with my grandma.
All right, so you need to stop inviting people to live with your grandmother when she's already have you living with her. You understand?
And
So were you supporting yourself at all? Or were you just dependent upon your grandmother?
I mean, I wasn't paying rent, but I wasn't.
Were you working? I'm sorry, I can't hear you.
Sometimes.
So that means that you're not bringing in a stable income and you're bringing somebody else into your grandmother's house. That's a big no-no. You understand?
Yes.
All right, probation, anything with Center for Healthcare Services or?
Your Honor, I think. And I know that the state waived and abandoned the other allegations, however. He last reported to probation in March. So that's a concern for us. Right before he absconded, he did produce one negative UA, the others were positive. He did not complete his hostility management course that was originally mandated. I think our concern would be that he would abscond again without actually getting the help that is necessary.
All right, do you want to go to prison? Because we can do that. Then why are you behaving as though you want to go to prison by not reporting? That's the easiest thing on the planet to do. You're obviously not working, really. So you're just watching television with your grandmother or something, or putting a burden on her where she has to feed you and then you're bringing a girlfriend into the house. That seems like all you were doing and not doing well on probation. Do you want to go to prison for up to 20 years?
Listen to this courtroom rhythm. The judge is no longer negotiating. This is accountability being spoken out loud. Miss a report. Skip a class. Drift off the radar. Each one becomes a brick in a road that leads straight to prison gates.
So that relationship is over. If you end up violating my order and having contact with her, you could potentially go to prison for 20 years. Do you understand? And we're going to do state ISF, cognitive and substantive track. And then we'll see where that leaves us.
Okay, Your Honor, I do want to point out that the way that state ISF is being ran now, it's not a double track anymore. It's either one or the other.
We'll do cognitive.
Thank you, Judge.
And then after that, when he's released, we'll put him on GPS, partial for work until further notice. And you to reside at your grandmother's house. You understand?
Oh.
And Your Honor, for Mr. Hanson's benefit, what are you looking for, or what is the court looking for so that he could get off GPS? I mean, just so that he knows, like, if he's always reporting, attending.
Oh, he needs to show me that he's actually taking this probation seriously.
Okay.
If you're not taking it seriously, what's going to end up happening is a motion to revoke is probably going to be filed. And instead of you worried about GPS, you'll be looking at potentially 20 years in prison. Do you understand?
Yes.
All right. And see probation if those fees can be waived.
Thank you.
All right, thank you.
Thank you. Thank you, Judge.
You're welcome. Annette Idrago. Who's here on Annette Idrago? All right, where is she? Have her come forward.
She's right here in custody.
All right, state on this case, my understanding she has a case, another case. And you all were going to be looking into that. Where are we on that?
She was, may I address the question?
Yes.
She was picked up on that this morning, Your Honor. There was a
Okay.
bond increase on the other case, is my understanding, for $100,000.
Mhm.
So I don't know if she's gonna make that or remain in custody, but either way, if I could just get a little bit of time to look at the new cases, you could call this back anytime.
All right, Ms. Ferguson, on Idrago, if I can have a 30-day reset, please.
November 28th.
All right, November 28th, and state at that time if you could tender an offer.
Yes, Your Honor.
All right, thank you.
Your Honor, can we do it the week before?
All right, Ms. Ferguson, can you put that the week before?
Thank you. Take my kid to Colorado.
Are you driving?
No.
Yeah,
My
that's,
in-law wants to go in an RV, but I don't want, I want to fly.
oh, okay.
That's perfect. Thank you.
All right, November 16th.
Thank you, Your Honor.
You're welcome. Okay, Orlando, if I can see you, can you put us on mute, please? No, I mean, I understand it was down for contested, but we were here for the email, so,
Well, apparently it's a phone that has all the information on that I need to see the communications.
all right, and do we know, one, what the phone is, and two, is the phone charged? Are we gonna have to charge it?
Your Honor, they are actually charging the phone right now in anticipation that this may, it needed to be produced. I would just need to, if it's going to be a true contested, I just need time to get the officer here with the phone.
All right, so when do y'all want to set this? How much time y'all need? Just to let the court
I
know.
just looked at it today, Judge. So
Okay,
it was special crime, but apparently they're too special to.
you're too special.
Handle this, okay.
All right,
Next week sometime?
well, I don't know if that's enough time for them,
Okay.
at least to,
Sorry.
what do you?
About whether we would, since it is a cell phone, my understanding, it was consensual, like as in the sense of the search. So
Okay.
that would just be a question. I don't know, that'd be an issue for defense, but
Well, I think they're making allegations that he was using the cell phone for this,
Well, I mean, is there going to be
Stuff and
objection because they're saying that the searching of the phone was consensual?
right, it may have been, but they're saying that there was communication on the phone that he was trying to hook up with people and stuff.
Okay.
He's disputing that aspect. So if he had a phone, that's another thing. If he's trying to hook up with these people, that's a different thing.
Okay, all right, Ms. Ferguson, can you recall that is 3 weeks enough time for everybody?
Yeah, that'll work.
Can you recall this in 3 weeks for potentially a contested? All right, November 16th. Yes. Mr. Bueno, we're going to bring you back on November 16th and they'll have the cell phone here for you. Oh, just have a seat unless they're ready to take you back. All right, so what is happening with this case?
Judge, I have an offer.
This is a silent but serious shift. Once your plea deadline expires, the court stops bargaining. From here on out, you are either fighting your case or standing fully exposed to whatever sentence the judge believes fits. No soft landings.
All right, Ms. Ferguson, this is 2 days. Can I have a jury trial date, please? And it's criminal trial division. All right, we'll be back on December 5th for a jury trial. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right. And counsel, you need to sign. Oh, I do have the acknowledgement of discovery, so that's done. All
Thank you.
right, thank you. Once you get the reset form, you're excused. Jose Ruiz, 2022 CR 4248A, State of Texas versus Jose Angel Ruiz. Can I have parties announced for the record for the state,
Brittany Mitchell and Marissa Giovanco for the state.
for the defense?
Lisa Connolly and Lorraine Efron.
All right, and are you Mr. Ruiz? All right, what would you all like to put on the record?
That in conferring with the state today, it's come to our attention that there, the possibility of some newly discovered Brady exculpatory evidence. And I understand that the DA's office needs time to work out arrangements with the attorneys representing the individuals who have the evidence and to turn that over. And so we are, obviously, we want all of the Brady and exculpatory evidence that we're entitled to, and we want an appropriate amount of time to deal with that. At this moment, I don't know how much time we would need to deal with it because it's not in my possession. But that was one thing. And then the other thing is that there are some pretrial matters that may require some rulings, such as a motion to suppress oral and written statements. Now, we're going to confer and see if we can reach agreements on redactions, but it's possible that we're going to need a pretrial hearing on some pretrial matters. So